Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For those in-house, we do ask that courtesy that you check that our mobile devices have been silenced or turned off as we prepare to begin. And for those watching online, we remind our internet viewers that questions or comments can be sent to us at any time, simply emailing speaker@heritage.org. And of course, for everyone, we will be posting the program following today's event on the Heritage homepage for future reference. Leading our discussion is Paul Larkin, Senior Legal Research Fellow in our Edwin Meese III Center for Legal and Judicial Studies. Mr. Larkin directs Heritage's Overcriminalization Project to counter abuse of the criminal law, particularly at the federal level. From 1984 to 93, he served at the Department of Justice as an assistant to the Solicitor General and as an attorney in the Criminal Division section on organized crime and racketeering. He has argued 27 cases before the U.S. Supreme Court. He then served as counsel to the Senate Judiciary Committee and head of the crime unit for Senator Orrin Hatch, then the panel's chairman. And from 1998 to 2004, he worked at the EPA as a special agent for criminal enforcement. And in the private sector, he has worked for two major law firms here in Washington, D.C., and as an assistant general counsel for Verizon Communications. Please join me in welcoming my colleague, Paul Larkin. Paul?
Thank you for the very kind words, John. I appreciate it. And thank you all for coming. You have a lot of uses for your time. I appreciate your willingness to spend some of it here today. I can guarantee you it's worth it. We are privileged to have with us today the authors of the book, The Campus Rape Frenzy, The Attack on Due Process at America's Universities. This is the book. It is on sale outside, and I urge all of you to get a copy. It is a very eye-opening read. The book addresses the controversial subject of campus sexual assault. The Campus Rape Frenzy explains that universities have overreacted to the problem. College officials are amateurs when it comes to the investigation of sex offenses, and unfortunately, they have used a rather amateurish approach in some cases. They have taken up the responsibility to investigate, prosecute, and adjudicate claims that are better handled by professionals in the criminal justice system. To offset their shortcomings, colleges have adopted over-inclusive definitions of the term sexual assault and have rigged the disciplinary procedures so that even amateurs cannot flub them. And the federal government has been their partner in this crime. The result is often, unfortunately, a disciplinary system that is only a pale imitation of a just one. Speaking first will be Professor Casey Johnson. Professor Johnson received his undergraduate and PhD degrees from Harvard University, as well as a master's degree from the University of Chicago. A historian, Professor Johnson is currently at Brooklyn College and the City University of New York, but he has also taught at Tel Aviv University in Israel as a Fulbright Scholar. He is co-author with Stuart Taylor of the 2007 book, Until Proven Innocent, Political Correctness and the Shameful Injustice of the Duke Lacrosse Rape Case, another excellent book on the subject. But he has also written numerous other books and articles. One book is Congress and the Cold War. Another is All the Way with LBJ, the 1964 presidential election, both of which were published by Cambridge University Press. And a third book is The Peace, Progressives, and America's Foreign Relations, which is published by Harvard University Press. Following Professor Johnson will be Stuart Taylor, Jr. Mr. Taylor is a graduate of Princeton University and Harvard Law School. He has written numerous articles for the American Lawyer, Legal Times, National Journal, Newsweek, Atlantic, The New Republic, Wall Street Journal, and Volokh Conspiracy. He has done numerous radio and TV interviews on all major news networks, except for ESPN. Work harder, Stuart. He has been a non-resident senior fellow in government studies at the Brookings Institution, and he also practices law occasionally. In addition to being a co-author of the book about the Duke lacrosse case, Stuart has authored Mismatch: How Affirmative Action Hurts Students It's Intended to Help, and Why Universities Won't Admit It. He and his co-author have written a book that Judge Posner described as, quote, the best researched and most convincing analysis ever done of affirmative action in higher education. Now, while these authors have very distinguished careers and have very different facets of their career that I've mentioned, they also have several traits in common. They know how to exhaustively research a subject, how to meticulously document their account, how to methodically present their case, and how to produce a polished, elegant work product. But they also have the willingness and backbone to challenge the prevailing orthodoxy, particularly on the campuses of what are supposedly some of the nation's premier institutions of higher learning. To quote the great Western philosopher Sandler, that's not too shabby. Please welcome these people so that you can give them your attention. I thank you very much again for coming, and now we'll hear first from Professor Johnson.
Thank you, Paul, for the kind words. Thank you all for coming. I realize it's a busy day in D.C., so I'm particularly appreciative that you all are here. The book attempts to describe what is in many ways a quite extraordinary phenomenon, and it is basically this, that over the last 6 years, we've been told, first by the Obama administration, then by much of the mainstream media, especially the New York Times, and by campus activists and their allies within the faculty and within campus administrations, that the nation's college campuses are facing an epidemic of violent crime. That solely in terms of the numbers of female undergraduates who will be sexually assaulted while they are enrolled at colleges, the typical college campus has a higher rate of violent crime, and in some cases a much higher rate of violent crime than any of the cities, Detroit, St. Louis, Baltimore, Oakland, that the FBI's crime statistics rate as the most dangerous cities in the country. And on top of this epidemic of violent crime must not be addressed in any way by law enforcement. It must be handled solely through the campus tribunal system. And then secondly, as part of this argument, the Obama administration, much of the mainstream media, campus activists, and administrators have argued that colleges and universities, which on gender-related questions, and you don't need me to tell you this, tends to be quite one-sided, and in many cases wildly one-sided, on the issue of sexual assault is one-sided in the exact opposite direction, that you have administrators, faculty, university leaderships who are so tolerant of the hundreds of thousands of unaccounted for rapists in their midst as to require an unprecedented federal intervention to order them how they should run their sexual assault investigations in a way that will be fair to female complainants on campus. That both of these approaches can be seriously argued is fantastic. It's essentially it's a perversion of what occurs on campus, but it formed the underpinning of the Obama administration's policies, which were adopted in many cases quite willingly by college and university leadership around the country, and which essentially created what amounts to a separate justice system that applies only to allegations of sexual assault, and applies only when a college student accuses a fellow student at his or her technically, but 99% of these cases, according to the relevant statistics, involve allegations against men in the campus context, accuses a fellow student of sexual assault. The fellow student must be a student at her own school. So these are tribunals that apply only within the campus context. So the rules of this procedure were established in two stages by the Obama administration's Office for Civil Rights within the Education Department, which reinterpreted Title IX, the federal law banning gender discrimination among schools that receive federal funds, first in 2011 and then in 2014, issuing guidance that did not go through the requirements of the Administrative Procedure Act, and therefore, if the Trump administration so desired, it could withdraw tomorrow with the stroke of a pen. These procedures establish that all sexual assault allegations on campus would be judged by a preponderance of evidence standard, so 50.0.1% chance of guilt. It established that accusers would have the right to appeal not guilty findings within the campus context, that there would essentially be no cross-examination of sexual assault accusers in the campus context. 2014 guidance held that cross-examination could in and of itself be construed by the administration as violating Title IX. That investigations needed to be quick, completed within 60 days, which, as we discovered in our research, frequently gave accused students insufficient time to prove their innocence. And that all campus tribunals needed to receive specialized training before they made adjudications, training that is coordinated by the campus Title IX office. So if you compare this to the criminal justice process, imagine a system in which jurors in rape trials, but only in rape trials, receive generalized training that was supplied by the prosecutor in that case before the jurors went into the box to make their decision. Anyone would recognize this was unfair. And this was on top of a system that already is not terribly fair to accused students. Students in campus tribunals don't have the right to a lawyer, there's no right to a discovery, and there's no open tribunal. So it should come as little surprise that this is a system, adjudications in the campus context have proliferated in the last 6 years, that has an unacceptably high level of risk of an accused innocent student being found guilty. The most recent study on this was by a UCLA professor, John Villasenor, who argued that at minimum, around 1/3 of innocent students are found guilty of sexual assault in the campus tribunal system. So how does this work actually in the real world? So I thought I'd describe in a couple of minutes a recent case that occurred at Ohio State University. One of the things about this system is that although these procedures apply to all of the roughly 7,000 colleges and universities around the country, there's an enormous discrepancy between elite schools, so top research universities, elite liberal arts colleges, the Ivy Leagues, where this issue has become an ideological frenzy, and where the amount of allegations are appearing at a much higher rate than at most other schools, and we can speculate as to the reasons why. The likelier is that there's a particularly intense ideological fervor on these campuses. The classic example was a couple of years ago at Swarthmore College in Pennsylvania, which most people would not consider to be a high crime capital of the United States, but in which more than 8% of the female undergraduates claimed that they had been sexually assaulted in the calendar year 2013. Anyone who believes that that's actually true would have to have their heads examined, and yet parents willingly spent $250,000 over a 4-year period sending their daughters to this institution. So this is a case at Ohio State. It involved 2 medical students. They met in the summer of 2014. They had a brief series of flirtatious exchanges. And then one night, the female student called the male student, asked if they wanted to get together. She was at a bar. He came, they got together, they chatted for a few minutes, they went back to his room, they had sex, and at that point, there was no relationship, but the interchanges between the two ended, and he went on his way in his final year of med school. 10 months later, the female student was informed by Ohio State that she was about to be kicked out because of failing grades. 2 days after that, this is someone who clearly understood the current environment on campus, the female student went into the Title IX office. She said that she had been sexually assaulted on that night 10 months previously. She remembered nothing of the event, she said, so she must have been either incapacitated by alcohol or perhaps drugged by a date rape drug, and, this was the kicker, she demanded an accommodation under Title IX that her academic probation be suspended and that she be allowed to remain a student in good standing at Ohio State, and the Title IX officer granted her that accommodation the next day. The case then went before Ohio State, which actually has a fairer process than most. They hire an investigator who then prepares a file that gets turned over to a 3-person trained hearing. Lots of institutions don't even bother with the hearing. They just let the investigator serve as judge, jury, and prosecutor all combined into one. But Ohio State never told its investigator about the fact that the accuser had received this academic probation warning. And so neither the investigator nor the hearing board, nor of course the accused student, learned that the accuser had a powerful motive to lie. But the accused student had other ways to prove his innocence. He in fact hadn't had anything to drink with this woman at all on the night in question. He asked the investigator to go to the bar, to request video surveillance, to speak to the bartender, to ask what this woman had to drink. The investigator said, that sounds like great advice, but sorry, we can't do it. Under Ohio State's procedures, we only speak to Ohio State students or employees. The bartender is not an Ohio State employee. You're out of luck. But he still had a third chance to prove his innocence. He said, all right, if you can only speak to Ohio State employees, he reached out to an Ohio State professor of pharmacology. The professor went through the accuser's own statement of what she had had to drink that night and prepared an expert report showing that even if we accepted what the accuser said as truthful, she was not incapacitated, she was not even particularly intoxicated, therefore her allegation would not be false. He asked that this professor be allowed to present testimony at the hearing. Ohio State's hearing officer said no, that under Ohio State procedures they don't hear from expert witnesses, even if they happen to be Ohio State professors of pharmacology, and the hearing panel found him guilty. So he sued. Requested temporary restraining order, which was denied. He had the misfortune of being in the Sixth Circuit, which is by far the worst circuit on this issue. But the judge did allow for a hearing in which multiple Ohio State disciplinary officers testified. 3 of them, under oath, said that they did not consider their obligation under the Ohio State procedures to get the result right. One of them, the victim's rights advocate at Ohio State, this again is a public university, said that she felt she had no obligation to step in if she knew that a student was saying a knowingly false statement in a campus disciplinary process. The case is ongoing. The guy was kicked out 4 months from getting his MD, and his chances of being a doctor are basically gone. So how has all of this been allowed to happen? In part because of the odd nature of these campus tribunals, where the one protection that the accused student has is anonymity, which means they have a real disincentive to come forward, and so you can only learn about abuses like this if you go through the legal filings, which are occurring 2 or 3 years after the incident themselves. Second is how the media has handled this issue, which has been disastrous. The issue has largely been framed by the New York Times, which has presumed the guilt of campus accusers. The preferred phrase is a survivor, but if someone who makes an accusation is automatically a survivor, then there's no question about the veracity of that accusation. And then third has been the odd politics of this issue. The political heroes on this issue can be, or basically you can list them on one hand. Lamar Alexander and James Lankford in the Senate have been the 2 key players, a couple of members of the House, but for the most part, Democrats and Republicans alike have been cheerleaders for the current guidance, which again remains in place. So how can all of this be changed? This is an extremely difficult process to change, in part because we have entrenched bureaucracies on campus. Harvard University alone has 50 Title IX officers currently employed, plus another 6 staffers whose sole job is to train another 30 people who live in the Harvard undergraduate houses who can provide counsel about how students can avoid sexual assault. And if your job depends on making sure that there's a campus rape epidemic at your college and university, you'll be very certain that there's a campus rape epidemic at your college or university. These are people who are ideologically inclined to see that as it is. But at a minimum, we need a couple of things. The first is that judges need to be more courageous about stepping up on these cases. Really, the only avenue for justice for accused students is filing lawsuits after they've already been found guilty. Judges traditionally show deference to university judgments on disciplinary matters. Universities deserve no deference on this issue at all. And secondly, at the bare minimum, the federal government needs not to provide harm. The current guidance issued by Obama in 2011 and 2014 remains in place. We're averaging roughly 1 due process lawsuit per week over the last year and a half. And as long as this guidance remains in place, the frenzy about which we write is unlikely to be remedied anytime soon. Thank you very much.
Thank you to Paul, a good friend who's also my encyclopedic source when I need to know anything about federal law. All we journalists need sources because we don't really know much except what our sources tell us, and when I need to know some federal law, I just give Paul a call, and there it is. Casey covered matters pretty well on the waterfront, and so I'll just add in little things here and there that he didn't have time for. I might mention that I have 2 daughters and no sons, and so if you look at my family situation, you might think that I would be more on fire about the survivors than about the falsely accused. And my daughters used to ask me, "Dad, why are you writing so much about rape?" And it was an awkward question to hear from your daughters, but over time, I basically said, because I care about injustice, and I keep finding that happening in rape cases, and Casey brings them to me if I don't know about them already, so I keep getting down this little channel. If I had to choose which injustices I'd write about, there might be some others, but these seem gross enough. I'd also like to mention that although we've got 2 male authors here, which might lead some to be skeptical of our point of view, there are some very strong, admirable, well-known, respected feminists who basically are the same side of this debate as we are. Just to name a few, civil libertarians, Nadine Strossen, former ACLU president, Kathy Young, a great journalist, Emily Yaffe, a great journalist, Christina Hoff Sommers at AEI, 4 of the 28 Harvard law professors who signed a paper denouncing what the government was doing and taking a similar position to ours are distinguished feminists: Jeannie Sue Gerson, Nancy Gertner, Janet Halley, Betsy Bartholet, and probably some others I'm not naming. So, in fact, I can't really think of a single serious civil libertarian, liberal or conservative in the country who knows anything about this issue, who isn't deeply disturbed by what's going on at the universities and by what the Obama administration did. Casey covered a lot of the specific injustices. A couple of things that I'd mention that happen in these cases is there's this pervasive presumption of guilt culture now at the colleges. Not only the faculties, a lot of them, and the administrations, and lots of sex bureaucrats that were hired at the demand of the Obama administration are into assuming that all accused males are guilty. One thing we found when we wrote the Duke Lacrosse book is that the student body seemed somewhat refreshingly open-minded on these issues and fair-minded. The campus newspaper, the student government, the students who campaigned against the crooked district attorney Nifong. So they were the one bright spot, at least we thought, on this presumption of guilt culture front in 2006 and 2007, not now. Over and over and over again, when we look at what happens on the campuses, you look at the University of Virginia after the Jackie fraud was completely belied, the one that Rolling Stone made famous. The student body, almost every student who's spoken up on this issue at the University of Virginia, they first went to presuming guilt, and then after guilt became impossible to presume, the line seemed to become, well, it might as well have been true because we all know that this is what's happening at the colleges. And so there's, if maybe 10 years ago I would have thought having a panel of students judging these cases would be the fairest thing, certainly better than sex bureaucrats, certainly better than a lot of the faculty. I'm not sure I'd say that now. The other point that comes to mind, when you look at what OCR does, they not only demand that their specified procedures be followed, they are hanging over the universities all the time, or they were at least under Obama. We'll see what happens under Trump. And the universities were on notice, I think Casey conveyed this to some extent, that they'd better roll heads, more and more heads as time went on, because we in the government know that there's a lot of rapes that aren't being reported, so you've got to work harder to get people to report them. And we in the universities know that there's a lot of guilty rapists that aren't getting punished, so you better start punishing them. And basically any university that didn't do exactly what OCR wanted it to do, was on notice that first they would get horrible publicity because OCR would put them on a list of universities that are under investigation for being soft on rapists, and second, then maybe all their federal money would get taken away. It would take a very courageous university leader to fight that, and I haven't seen it happen. I think one university is fighting it, a small Christian school in Oklahoma. Maybe they don't get much federal money, but I've talked to a board member of a university who says, we cannot fight this. We have to do what they tell us, because otherwise they'll smear us with bad publicity, and they never even get to taking our money away. They'll smear us with bad publicity, and then when young Mary or little Johnny and their parents sit around the breakfast table deciding, well, which of these colleges should we go to that accepted us, you get crossed off the list in a lot of families if you've been publicized as a soft on rape campus. And so apart from the specific rules, there are all these atmospherics. There's also rules on consent. Consent has been redefined, and I'm looking for the piece of paper. Activists have redefined rape, and this is true both in a lot of the rules universities have adopted. That's one thing the federal government has not defined. They have not defined rape. They have not defined sexual assault. They left that to the universities, which has, in many cases, maybe most, defined it in a way that includes as sexual assault, sexual misconduct, or rape. They use different phrases. All kinds of conduct that is clearly legal. It's not criminal. Some of it may be distasteful, but it's not criminal, and it's not generally regarded as criminal. For example, at Brown, one accuser said, not that she said no, not that she said stop, not that she was forced. She said a guy manipulated her into having sex, manipulated, and he actually had used the word. That was an unwise thing of him to say, as in wheedled on her, nagged at her, oh, come on, come on, come on. Well, Brown disciplined the guy on that basis. Clearly legal, maybe not tasteful, but clearly legal. University of Wyoming, this comes from their definition of sexual assault. Anything less than voluntary, sober, enthusiastic, verbal, non-coerced, continual, active, and honest consent is sexual assault. Well, you can imagine that covers an awful lot of ground. By that standard, moving forward, even after a clear assent is less than, that is not quite enthusiastic, is by definition sexual assault. Catherine McKinnon, much lionized militant feminist scholar, law professor, famously said, quote, this was in the 80s, I think, "I call it rape whenever a woman has sex and feels violated." And that sentiment, which once seemed pretty far out to a lot of people, has now been enshrined, or close to been enshrined, in the disciplinary codes of a lot of colleges. At Duke, we heard about Duke. Well, Sheila Broderick, who's now the Gender Violence Intervention Services Coordinator, and I'm not sure where that puts her on the rather large hierarchy of sex bureaucrats, she said, quote, "If the campus disciplinary panels say he's not responsible, well, you and I know he's responsible, and that, at the end of the day, is what it really means." Translation, every male who is ever accused of sexual violence by a female is guilty, even if the campus's tribunal finds him not guilty. Last thing I'll mention is, apart from sex in the sense that libido, rape, that kind of sex, or non-rape, the universities, and to a large extent the Obama administration, have gone a long way toward destroying free speech on campus by using an absurdly overbroad definition of sexual harassment. Sometimes they'll use it as racial harassment or gay harassment. This began in what the Office of Civil Rights hailed as a blueprint for colleges and universities throughout the country. They forced the University of Montana to pledge to punish as sexual harassment any unwelcome, quote-unquote, speech of a sexual nature, and of a sexual nature would include things like, "I think men are better at football than women." That's talk of a sexual nature. Or even if an objectively reasonable person of the same gender in the same situation would not find it offensive. That's sexual harassment. The university must investigate it. And it goes on, but I think it's probably time to invite questions. Thanks for listening.
Let me take the moderator's prerogative and ask the first question. I suppose one of the rationales for the very aggressive position that was taken in support of the Title IX guidelines was that because it's so difficult for individual women to come forward, they're only likely to come forward if there is a legitimate claim of rape. And the number of illegitimate claims, unfounded claims, is likely to be so small that you really need to accept that everyone is valid in order to encourage women to come forward. Well, given what happened at Duke and given what happened at UVA, we know it can no longer be made reasonable to say that no woman is going to file a false claim. But suppose the argument were changed. Suppose it was just 75% of the claims are legitimate, or 2/3 of the claims were legitimate. Would that be a sufficient justification for the rules and the climate that has now been developed as a result of the rules?
I think there are two problems with this. The first affects accused students, the second affects colleges. For accused students, the problem even with this as a scenario is that each case on paper has to be judged on its own merits. So there's no way of knowing in an individual case if this is one of the 25% of cases that were false, and so the basic assumption would be, well, we're just going to kick the guys out anyway. The bigger problem to me, and the reason that I'm involved with this issue, is I'm a college professor, and at least on paper, the only reason that colleges and universities have for existence is the pursuit of truth. If we're no longer in the business of pursuing truth, we no longer have any reason for being around. And these are systems in which colleges and universities are willingly, because they're not fighting the federal government on this, except for in Oklahoma Wesleyan's case, are willingly making these life-altering decisions about their students on the basis of wildly incomplete bases of evidence. They're guessing, and you can't have a college and university system that says, all right, we have this one area where we've set up procedures where we can't find the truth and we basically don't care. But in all other aspects of college and university actions, we do care about the truth, trust us. That just doesn't work. So the Title IX prosecutions are fundamentally corrosive to the basic nature of higher education in the United States.
I'll just add one example of how far the thinking that you mentioned has been taken. A representative named Jared Polis, a Democrat of Colorado, was at a hearing on this issue, and he said he wondered whether OCR, the Office of Civil Rights, needed to weaken due process even more, and he mused that maybe colleges should adopt a reasonable likelihood standard, finding accused students guilty even if the probability of innocence is greater than 50%. Somebody objected to this, and he got further. He said, maybe one or two, let's say, well, maybe 1 or 2 of 10 accused students are guilty under this lowered standard. He said, maybe universities should expel all 10. This was said in a House hearing. All 10, expel them all, just to be sure. He repeated these sentiments in a post-hearing interview with Reason Magazine's Robbie Sove, and Suave, I think it's pronounced. And that's, when you're dealing with thinking like that, I'm not sure where to start.
Well, let me just follow up one question. The Obama administration put out this guidance through the Department of Education, the Office of Civil Rights. Did the Obama administration ever go to Congress and ask Congress to change the procedures in rape cases or change the definition of rape so that the way it was handled in the criminal justice system would match up with the way they wanted it handled on campuses?
It did not, and in some ways the best soundbite of this entire episode was, I think it was 2014, and Catherine Lehman, who's now chair of the Civil Rights Commission, but then was head of OCR, is asked by Lamar Alexander in a Senate hearing, under what authority did you do this? And Lehman's argument was that because the Senate confirmed her as Assistant Secretary for Education and head of OCR, that the Senate gave her the authority to rewrite federal law in these approaches as she saw fit, and therefore the administration had no need to go to Congress to request additional authority. It's just an extraordinary statement.
I would now like to call on the audience. If there are any questions, let me just ask first, you identify yourself. Second, that it really be a question rather than a statement. And third, that it be relatively brief. Over there, far right. And that was not a political joke.
You'd be accurate. Okay, can you hear?
Yes, I can.
I'm just kind of thinking about this problem from the parental perspective, because I have 3 boys that are about to go to college. If a campus seems to be celebrating some kind of rape culture, which is weird, I've read stories where they seem to talk about this as though it's a good thing, are they required to provide this information in marketing materials, recruiting materials to parents and their families? And if they don't, doesn't this open them up to all kinds of liability, perhaps down the road?
Good question. I'll start, and Casey may know more than I do about what they do in their recruiting materials. I'm not aware that they say much about it. I think they talk about how great their prevention programs are. But another way of coming at the question is, suppose they seriously believed, and the universities are saying, oh yes, 1 in 5 are raped and so forth, that's their line. The Association of American Universities did a kind of a phony survey that led to that conclusion. They're not doing anything serious about what they say is this violent crime epidemic. They don't bring more cops onto campus. They don't separate the sexes in dorms or in bathrooms, for that matter. They don't talk about going back to single-sex education. All they do is bloviate and selectively punish anybody who has the misfortune to be accused of sexual assault. But Casey may have something to add.
Yeah, the only federal requirement in this regard are the Clery Act requirements, where if there are allegations of sexual assault, they're required to report it. And those statistics are very interesting statistics because they disprove the 1 in 5 claim. They come in far, far lower than that. And there is this bizarre approach where universities, if you go to the website, say, of a typical university's women's center, you'll see long elements of description about how we have a rape culture on our university and we're doing X, Y, and Z to address this. And that usually means holding events at the women's center or hiring more bureaucrats. But if you look at the marketing tools of universities, if you go to any admissions website, you see no mention of this at all. Just how wonderful this school is, and you're in these dorms and you're safe and blah blah blah. Yeah, so I'm not aware of any university that's come clean on this issue.
No footnote that says, oh, by the way, your daughter has a 1 in 5 chance of being sexually assaulted if she comes here. I don't think any of them have said that.
Can I follow up at that? Then I'm going to get to Hans' question. Could someone a male student, let's say, because 99% of the defendants are male, could he legitimately raise a fraud claim against the university on the ground that, somewhere they should have told him that he was at risk of this kangaroo court system? And by not telling him, it's like not telling the buyers of a stock that there is some material fact that they should have known. I mean, the fraud laws in federal court have been expanded rather broadly. Could someone make that sort of claim?
It would be difficult to do because these procedures do exist on the university website. You often have to click 17 times to get to where the procedures are, but they're there. The most common of the lawsuits by accused students have been breach of contract claims, where they're arguing, it's not a fraud claim, but they're arguing that the universities aren't even following their rigged procedures. And those, more accused students have won lawsuits than have lost. But I haven't seen any that's used a fraud claim thus far.
A lot are due process claims, too, especially when it's a state school. The conventional wisdom is that private schools don't have to give due process, but there's also an interesting theory by Jed Rubenfeld of Yale Law School that actually they do, that if what they're doing is punishing crimes or alleged crimes on orders of the federal government and using procedures that the federal government itself could not use to punish the same crimes, that they're on the hook as state actors. That hasn't caught on, but I hope it will.
Hans, I know you had a question.
Hans Mosbacott from Heritage. Just on your question, I think a gender bias claim was actually raised by a male student at Washington and Lee University. The circumstances in that case were even worse than the Ohio case, and Washington and Lee actually ended, I think, settling the case because they didn't want more publicity about it. My question, though, is, look, sexual assault is a very serious criminal offense that has horrendous effects on the victim. It also can have a horrendous life-changing, life-damaging effects on someone who's falsely accused of it. Isn't the real problem here the fact that university tribunals, which were designed to handle things like cheating on exams, they should not be handling this? Shouldn't all of these cases, anytime sexual assault is charged, shouldn't that be forwarded to local police officials and prosecutors who actually have the training, the ability to investigate properly, the experience in forensic matters to actually handle this the way it should be handled?
Absolutely. Imagine we were living in an environment in which the federal government had ordered colleges to adjudicate in these campus tribunals all attempted murder allegations. When one student attempted to murder another, it would be seen as laughable, or armed robbery, or serious drug dealing allegations. And so what we've done is we've taken this one very serious crime and said that federal government said the colleges have to handle. And these systems, and I speak here as a longtime professor, these systems work very well, by and large, when they deal with academic misconduct issues. And the reason that they work very well in these issues is that basically the allegation is presumed to be true. If I accuse a student of cheating on an exam or plagiarism in a paper, the assumption is that I, as a professor, know what plagiarism is. I'm not making this argument up. And the sole purpose of the disciplinary system is to make sure I'm not engaged in some, retaliatory behavior against the students. It's to check abuses. But that's not the case in sexual assault. You can't simply presume from the start that the allegation is true. And in a way, the only real defense of this system is if you accept that premise. If all sexual assault allegations are true, the campus system actually is a really good system because the complaining student is treated very, very well. She's not asked any hard questions. She doesn't have to be cross-examined. She doesn't have to produce evidence. For instance, a case we write about, a very, very troubling case at Amherst, where the complaining student is texting on the night of the incident, talking about her need to construct a good lie because she has seduced her roommate's boyfriend. But Amherst didn't require her to turn over these texts. That's why she didn't go to the police. So in a system where you don't have to turn over any evidence that might be used to impeach you, this is a great system. But it's bizarre, because again, if you accept the premise as true, that we have between 400 and 500,000 violent crimes every year on campus, that's what the 1 in 5 figure translates to. How can the police not be involved in this? It would be the most serious criminal justice system in any law enforcement area that has a college or university.
Just a quick footnote. I agree, but I'll play devil's advocate for a minute for the other point of view, which is it's very hard. Let's imagine a real victim of a real rape, and of course there's plenty of those on campus, off campus, all through human history, not 1 in 5, but more than there ought to be. There's lots of reasons why a woman would not want to report it to the police. Even if the police are exemplary, it's a harrowing process to go through. You might get some publicity. You'll get cross-examined by a defense lawyer whose job is to make you out to be a liar, even if you're clearly telling the truth. It's not a nice process. And so you can see why some people think, well, why don't the colleges have a kinder, gentler process for rape victims who don't want to go through the hell that they go through in the criminal process? The answer is we've seen it tried, and the cure is worse than the disease. The universities are utterly incompetent, utterly biased in this zone, and there isn't any alternative to law enforcement, any good alternative.
Hi, I'm Ron White. I'm the Dean of the University of Baltimore School of Law. Friend of Stuart, friend of Paul, thanks very much for the book and for the presentation today. But I want to take issue with, I guess, maybe Paul's framing of the issue as, the amateurs are in charge and we should let the professionals of law enforcement do it. And really, Casey's answer, Professor Johnson's answer to the question before, and I want to sort of probe the question of whether there's any business for universities to be investigating this kind of conduct. Why isn't this analogous to an employer disciplining an employee for conduct that may not rise to criminal conduct or that can be proved beyond a reasonable doubt, or the military disciplining soldiers without invoking the military criminal code, or police departments disciplining improper conduct by police officers that may not rise to criminality? I guess my question is, wouldn't it be a sounder position to say that we need more fair processes and a higher burden of proof in these cases, but that we recognize that a campus has an obligation to investigate and perhaps adjudicate and sanction improper conduct that may not be criminal conduct? And it's not just, Stuart, that the criminal justice system is harrowing for victims, it's that it may not be provable to the standard that we require of the criminal law, but that it's conduct that should be disciplined, as cheating is, Professor Johnson says, or perhaps alcohol use on campus or drug use on campus, that we wouldn't bring in the heavy hand of criminal law enforcement, but we'd recognize that a campus should be making sure that this conduct isn't permitted.
Ron, I think you raise a very good question. I think two answers come to mind. One is, of course, colleges do discipline sexual harassment, as do employers. Nobody claims that sexual harassment is a crime, at least not that I've seen. They do claim, when they say, oh yes, we're going to kick this guy out for sexual assault, sometimes they call it sexual misconduct, but it's almost always either implicitly or explicitly fingering him. He committed a sex crime. And universities have no business at all doing that, in my opinion. If what they want to do is say he did something sexual that violates our own rules, let's call it sexual misconduct, but not a crime. Call it sexual harassment. And if you had adequate definitions, and if you had people who can be trusted to decide these cases fairly, as opposed to people in a system that's dominated by extreme feminists, often of the male-hating variety, I could see what you're talking about as theoretically acceptable. In this country, given the universities we have, I don't see it working.
Yeah, and one other thing about that is that one of the differences, I think, between this and a cheating case is that, and we talk about these cases a lot in the book, is that a lot of times that to get at the truth of these allegations requires tools that universities simply do not legally possess. One of the shocking things to me about researching this book was the degree to which many of these cases are not, in fact, he said, she said cases, that there is additional evidence, usually it's some kind of text or other electronic evidence, which universities cannot legally subpoena. And so people on both sides, whether they're, a guilty student can conceal this evidence as well. So I don't see a way in which a university system in dealing with this can be structured in a way to get at the truth. And the difference, I think, between the alcohol and drug issues, which are criminal offenses, which generally are handled in a university context and not in a criminal context, is that you can think of this as a kind of nationwide compact. That all sides agree, the accused student, the university, the local law enforcement, and public in large, that yes, if you're underage drinking, this is technically a criminal offense, but it's better that we handle this in the campus system because we don't really think of this all serious. But at any time, this can be withdrawn. So in the Duke book, for instance, there were complaints by the neighbors in the Duke area that Duke students were drinking to excess. And so the Durham police in 2006 said, fine, we're going to prosecute these as criminal offenses because the local society has concluded this is a criminal offense, we want it prosecuted. And my sense is that anytime you get, let's say, a university that has heavy drug use, that the law enforcement always has the opportunity to step in and handle these criminally if they so choose. But I just don't see how universities can get at the right result procedurally on this question.
The far side.
I'm Nelson Lund from Scalia Law School. This question is related to some questions that were asked earlier, but I wanted to ask specifically about the legal theory that these rigged systems themselves violate Title IX. And I wonder if that's been tried in the courts, and if so, what do the courts have to say about it, if anything?
It has been tried, and the best decision we've seen on that front was by the Second Circuit. 3 Democratic-appointed judges. I think the opinion was by Pierre Laval, and the others were John Coltle, and I'm trying to remember the other. This was a case where, was it Brandeis? Columbia. Yeah. The allegation was there was a Title IX violation alleged. This is on a motion to dismiss. And Columbia said, well, hey, even if we were discriminating against accused people in sexual assault cases, that doesn't violate Title IX because our motive was not hatred of males. Our motive was fear of the federal government and the activists. And the Second Circuit, to its great credit, said, no, that doesn't fly. We don't care what your motive was. If you're discriminating against males in your sexual assault hearings, that's a violation of Title IX. It hasn't been adjudicated all the way yet, so we'll see where it goes. More broadly, I think, I'm not sure Casey agrees with me on this, he can say, I think when you have a system that systematically across the country, particularly when it's under the aegis of the federal government, systematically across the country discriminates against the accused people in these cases, even though they have a titular, yes, you could accuse a woman of this, but 99% of the accused are males. I think that's a pretty good Title IX violation right there. Now, you don't have to prove disparate impact. I think the natural and probable consequences of systematically discriminating against accused people in sexual assault cases is discrimination against males. Casey may disagree.
Yeah, the Columbia case, Columbia then sought a full hearing before the Second Circuit, which they denied, and they very quickly settled thereafter. So this is now precedent in the Second Circuit, which is really going to be important going forward because a lot of these cases come from, there's a lot of good schools in that area. There have been at least 2 district courts that have sided with accused students in Title IX claims. One was the Washington and Lee case. The second, the most recent case, was at Amherst. They haven't adopted a theory as broad as Stewart's is. Basically all of these cases have argued that they've basically said that we need something beyond the fact that this system is just discriminatory against male students because males are mostly accused. We need a particular atmosphere on campus which suggests that universities need to rig the system. But on paper, absolutely, this should be a legitimate Title IX claim because if you go from the start, OCR's argument was that Title IX gave OCR authority to dictate these procedures because women are disproportionately victims of sexual assault. If that's good enough for OCR, at least in theory, it should be good enough for the courts. The case to watch here is the Amherst case because the facts of the Amherst case are the worst of any facts that we have encountered, and it's in a circuit, the First Circuit, which has tended to be quite hostile to accused students. And so if that case can survive, then basically any case can survive.
Sir, right here in the front. And then
Hi, my name is Dave Price. I'm a freelance writer. Obviously, rape is a huge problem. Now, you present, as you said, Mr. Taylor, cure worse than the disease. So neither of you know how it's going to play out. I mean, we don't know. But we have a problem. Could you speculate a little bit on what you see? It needs a solution. It's not an easy one, obviously. But what you see happening along these lines. I mean, you mentioned some of the court cases, this kind of thing. But there's not an easy solution, but is there a 3-step, 4-step, some kind of thing?
Well, the biggest, major change in direction, the only people who could make it happen are the Trump administration or Congress. I think history shows Congress isn't likely to do anything that would serve my needs. The Trump administration's a big unknown quantity here. Betsy DeVos has not really said anything on this issue. She doesn't have much of a staff. There's no head of the Office of Civil Rights. We do know that the Trump education agenda, they're big on bathrooms, really big. They're big on vouchers and charters. And so far, they're not so big on the problem we're talking about. I hope that they will do one thing clearly and fast, which is erase from the books everything the Obama administration has done to destroy due process, which could be done with a stroke of a pen, because They destroyed due process by a few strokes of the pen. They didn't go through notice and comment rulemaking. They didn't go through any kind of a process that would test legitimacy of their theories. They just decreed them and ordered the colleges to follow them. That should be easy to get rid of. I hope that Trump will do it. What I think I'd like to see, and this may be more pie in the sky, is that wouldn't really erase the problem, because we now have, the colleges have all adopted rules that conform to the Obama mandate. They've all appointed squadrons of sex bureaucrats who tend to be enthusiastic about the Obama point of view on this, and those aren't going away. The universities, the activists are very powerful. You know, Trump saying the federal government's going to stop pushing you doesn't make that go away. I'd like to see the administration very carefully go through a notice and comment rulemaking to determine whether we've got a serious problem of sex discrimination against males in this area. And if they decide they do, should lay down some orders making it clear that Title IX is hanging over you, universities still, but not quite in the same way that it hung over you before.
Woman in the back there?
Thanks. I'm Peggy Orchowski. I'm the congressional correspondent for the Hispanic Outlook on Higher Education. I was going to ask about Title IX, too, and what the Trump administration might do, but you've somewhat answered it. So let me ask you something else. The new politically correct word now on campus seems to be safety, to the point where faculty are required to wear safety pins to show that they are safe for, mainly it's LGBTQs. But I'm wondering if there's some legal responsibility of colleges to provide a safe environment, whatever that means.
This is a difficult question to answer. It's a buzzword on campus, and it's been defined beyond all recognition. But in some ways, it started with the accusers' rights movement on this issue. So if you go back to 2010 and 2011, which is when this issue started to pick up steam, safety was always the buzzword, and the argument was that students have a right to a safe environment on campus. And sometimes the argument was even that this was the primary right of a college or university to provide a safe environment on campus. There is no reasonable definition under which it is the primary right of a college or university to provide. And the other thing about this issue that I think we often overlook is that before I went to Brooklyn, I taught for 4 years at Williams College, liberal arts college, upstate Massachusetts. Most college and university students do not have the experience of a Williams College student. That is, that they do not live on campus in a dorm for 4 years. The vast majority of campuses are living, vast majority of students are living, in apartments, in houses, off campus. And so they have no more right to safety than a non-college student does. I mean, we hope that local, state, federal governments are keeping us safe, but there isn't a free-floating right to safety that applies if you happen to be a college student, because it suggests that college students, get sort of special rights. In a lot of ways, one of the most offensive aspects of this movement from a victim's rights standpoint is that all of the best federal statistics, and really all, I think, of the statistics that we've seen, suggest that women who are 18 to 24 have the highest incidence of being victims of sexual assault. But the rate is higher for non-college students than for college students. And if you listen to the New York Times or to the Obama administration over the last 4 or 5 years, if you're a victim who happened not to be in college, you're basically out of luck. There's no indication that the victims' rights movement cared about you, that the administration much cared about you. And so there's this sense that if you happen to go to an elite school, we'll really take care of you. But otherwise, you have no right to safety at all. There's an elitism within this movement, which, when you sort of dig down into it, is really quite troubling.
And I might add, as you go down the income scale in terms of the Bureau of Justice statistics, the likelihood of a young woman being a rape victim goes up and up and up as her income level goes down and down and down. And so this, the kind of double standard that we really, really, really want to protect college women from rape and the others are on their own is especially striking.
Well, unless there's any more questions, what I think I'd like to do is thank our speakers for taking the time to come today and thank all of you for listening to them.